What's up, viewers, subscribers, and agents alike? This your boy Enlightened Luciferian Prince coming at y'all once again. Welcome again for viewing this content, for viewing this channel. If you're first time viewing this channel, like and subscribe. Please share, get the word out there. The more ears and the more minds on these topics is the better we can help humanity. We can tear the veil together. Now, if this is your first time viewing this channel, I always go through my disclaimers first before I lean into the topics. And let us start by saying this is for informational and educational purposes only. Number two, I'm not a lawyer. If you're in a legal problem or you have some legal troubles or whatsoever, please consult an attorney who is not licensed, but so-called authorized to practice at the bar. That's another video for another day. And then handle your business accordingly. Now, lastly, because my video content is not for children, with some exceptions made throughout the course of the progression of my channel, this video, however, is not for children. So, if your children are 18 and younger, please escort them with due diligence. Parents, it's your job, your responsibility to make sure no violations occur on my channel whatsoever. So with that being said, now that we got that out the way, this is Securitization Part 2. Now, earlier I did a 30-minute video on securitization. I said I was going to come back with the second part because I gave people a chance to basically delve into the information and see where exactly they fit into the scheme of things, along with other studies and along with other definitions and materials to assist you upon the way. Now, this is a very lengthy subject, and I'm doing this in parts because to give it to you all at once, like I said again, precept upon precept, line upon line, here a little, there a little. Don't want to overwhelm the audience with the information given. So now that the children are out the way, let us continue and proceed with part 2. Now, where I left off, according to notes that I formerly have, I want to break it down in such a simplistic sense to where it's not overwhelming and it's not going to basically weigh you down. You understand that everybody's distinction of education in regards to certain stuff is very different. And I'm here to basically make the line a little bit clearer so you can actually have the explanation and the information that you can proceed with your particular subjects within your own personal life. Now, let us proceed. There is a duality that exists here. The bank is the creditor for the receivable side of the asset side, that is the receivable, i.e. like a check. Very simple. You are the creditor on the liability side or the accounts payable. You can use your accounts payable as an offset or in counterclaim to the financial asset side, that is the receivable. The bank or the court is using the receivable side of the accounting ledger. Now, notice it said the bank or the court. Now, definition-wise, the word bank and banco in Latin also apply to what a judge is. A judge is a banker, people. I don't know why people don't understand that this is correlative, but that's the duality behind a judge's position, is to play banker. Simple as that. If you look up the word bench in Latin, if you look up in Black's Law Dictionary bench, it tells you it's a banking seat. So all judges are doing is drawing up debts and making the natural person pay it. Even though they do it under the guise of legality, i.e. with your consent, it is unlawful because what they're doing is making securities to fulfill the obligation of the debt. Now, if you follow me for some time, you know that I always use a particular word called constitutor. A person who is a constitutor swore by a simple pact to pay the debt of another. And this is always the principal obligation. Bouvier's Law Dictionary, 1865. This is the legal definition of what the principal obligation is. So when you're charged with anything, with the exception of harming a person or their property, those are the exceptions to the rule. But anything else is negotiable. Judges, he or she puts a debt against a straw man, and by coercion, deception, and misleading pretenses makes you pay for it under coercion. Law enforcement is just that. It will not work unless there's some force involved. Understand that's what it is. It is not to protect and serve, as they also draw on the side of those policy vehicles. You see what I'm saying? They are just enforcing policy to raise revenue for municipal bonds, people. That's the truth. Now you wonder why so many police officers out of egregious acts get away with a lot of stuff. Because they're bonded, they're insured. So since they're bonded and insured, there's no liability on their public side as being officer in executing their police powers and their duties. Understand, people, these are things you need to know. But not putting the cart before the horse, let's proceed. On the receivable side, you have to pay the debt. See what I'm saying? Jail time, probation, community service, fine or fee, or a combination of all the three. See what I'm saying? So, because that is where the charge is coming from, since they are claiming to be creditor, like a bank collecting the mortgage. The mortgage side of the ledger is the bank's asset and their receivable. But on the liability side, because they sold our gold. March 9th, 1933, the United States also placed it into positive law that anyone who owns gold can be fined up to 10,000 years, 10 years of prison, or by both. In other words, that is the principal obligation stuck inside of an executive order. This is law. Look it up. March 9th, 1933. This is it. Then you look at the act of April 5th, 1933. All of these are successive acts. Then you look up the Social Security Act, which was 1936. And then you look up the Administrative Procedures Act, passed 1946. This is what created what is called the Democratic Reserve System, i.e. slavery, i.e. nothing more than couched up socialism. That's all it is, people. This is written in United States law. Not saying it is law, it is color of law, as I said in the previous video. But you do your research. I gave you the guidepost to get there. Just to show you that I'm not talking out the side of my neck. I'm not making anything up. These are executive orders that are on the books. So, we have the actual gold contract where they did this. It is not my opinion. We had 11 $50 million gold bonds sold from a Delaware diamond company. They sold America's gold under contract to the Bank of China. It's not my opinion. The U.S. did not go bankrupt in 1933. What they did was sell the gold under a gold contract to the Chinese government. So the U.S. had to give us an account payable as a cash receipt. FAS 95 tells us when they did a credit to a transactional account, which is a liability account on which we are the creditor. I said that in my previous video. Go watch it if you didn't. They gave cash receipt to the customer and a cash payment to the bank because it is cash proceeds. In intermediate accounting, where you give them a promissory note. Hence, when you sign for a mortgage or you sign for a loan or you sign for a credit card, your signature pays it off. But they trick you and they use a negotiable instrument called a promissory note to use that as a negotiable instrument to pay it back as if they paid, and now they can say because they have your signature, you accepted the liability. So when you sign a mortgage but you don't sign the promissory note, you own your house free and clear. But they will never close on the sale until you sign that promissory note. That is direct and basic information to prove that they are committing fraud. If you sign on the mortgage as the acceptor, but you don't sign the promissory note, 99.9% of the time, they will not close out that sale. The 0.01% is where they're going to send it to their attorney. They're going to say, well, don't bother with it. Because they cannot monetize the promissory note without your consent to pay them back for something they never gave you. Contact me via consultation about denial of the loan. Loan company never paid you anything. They never even financed you. You financed yourself because you have in your perpetuity creditorship. But that's a topic for private discussion. Consultation only. Now, the mortgage side of the bank ledger is the bank's asset and their receivable, promissory note. But on the liability side, they sold our gold. We have the actual gold contract where they did this. Okay? Told you that. There is someone or something here that sent the transaction to the IRS on a closed checking account. He got the canceled check back from the IRS. They said the check is no good because it is a closed account. But the transactional marks on the back of the check say otherwise. If it is a note put into a bank, it is a cash receipt to the depositor and a cash payment to the bank. So when the bank processed the closed check, the IRS got a cash receipt and the bank got cash payment. Then the IRS sent it back. So it is evidence that the transaction is accepted, but they colorably and publicly claim it is no good. Remember when I told y'all about filing the UCC1 on my video about how I got into the back door? No diddy. But the reality is these people are full of shit. The person from the Secretary of State and the one that actually filed the documentation knew that it was filed correctly, but publicly they had to deny it. If you go back to my video, you'll see. This is what they do. Because again, in the mechanism of commerce and how all of this plays out regulatorily, you have to understand that these people do this as a matter of fact basis on business and commerce. You're getting robbed day by day, people, because my people perish for lack of ignorance. Hosea chapter 4, verse 6. Look it up yourself in the Holy Scriptures, right? Cool. The publisher accepted the note and hired an attorney, as they always do. You send them a letter and then they drop the matter since they know that you know what the accounting is for. Under FAS 140, you get what's called a set-off. Now, if people try to tell you these things don't exist, always refer to the code and have it in black and white. You cannot deny black and white. You can argue a statement because it's not evident. What's evident is a black and white piece of paper with the corresponding code on it, so they know that you're not stupid and you're not just sitting here spewing hogwash. Because without evidence, and you have it none to the contrary, they will argue and say that you're out of your damn mind. Don't give them that opportunity today, people. Be as wise as serpents and as innocent as doves. Now, a HELOC, HELOC, is different than warehouse lending. I got this from a mortgage department. They take the proceeds from the promissory note and pay the warehouse lender. So the debt on the real estate is distinguished from the books. That's why they call it closing. Okay? They are required to file a FR 2046. This is a balance sheet under 12 United States Code 248 and 347. Mark those down, people who are dealing with mortgages. They are required to file a balance sheet. They are required on a quarterly or weekly basis. They file these balance sheets with the Federal Reserve Board. I talked to the head of the Federal Reserve Board. They file a balance sheet with the board. The balance sheet shows assets and liabilities that they are used in accounting. The liabilities would be your promissory note. It is a liability because it is an asset to you. Did I not just say that? Yes, I did. I just said it. Securitization is the process of transferring the liabilities off the balance sheet. They can do this because you never ask for them. They have everybody conned into believing we are debtors instead of creditors and do not know how to ask for our assets. We never ask for recoupment, so why carry the payables on the books if they have been abandoned? Why not write them off and then ask for more cash? Mark that down for yourself, people, in this part of the video, right? Make sure you understand the guidelines of these laws so that way you are not left outside of how to do these processes for yourself. The government has such complicated books, it's impossible to figure out what is really going on. If you give a bank a promissory note, they are required to give you a cash receipt. Yes, people, look at the laws I just cited. If you try this stuff, it is not illegal. This is on the books per law. So if they try to dissuade you of that, it's only keeping the fox away from the hen house. You see what I'm saying? In regards to that, basically it's them trying to tell you, you know a little bit too much, but it's best that you handle your affairs clandestinely. Never let your left hand know what your right hand is doing. Simple as that. You go in the bank by yourself. Don't go in there with company. Go in there by yourself and handle your affairs on your private side, and you'll get the recoupment you desire. But go by yourself. And please don't try to be sneaky and try to record stuff and all that stuff. Trust me, people. Doing it over the phone and all that stuff is cool. But then again, never let your left hand know what your right hand is doing. Walk in there with the requisite law, handle your business, handle it accordingly. I can't make it any more simpler. Simple as that. I'm just reading to you all the corresponding laws to show you that this is not something that is totally mundane. Like you basically like, that stuff doesn't work. A lot of naysayers that come on these wavelengths and try to say that shit, they never did it themselves. Had I done it, I wouldn't be able at liberty to tell you publicly. This is a general channel. Consultation-wise, it's a different story. Now, they call it an offset in accounting, but in the UCC, it is called a recoupment. Unless you do ask for or do a defense in recoupment under UCC 3-305 and a claim under 3-306, you have a promissory and properly claim against the cash proceeds under the liability side of the ledger. UCC 3-306. There cannot be a holder in due course on a promissory note after they deposit it. The lifespan of a promissory note is 90 days. They do it in off-balance sheet entry. This means they take your note after they sell it. Instead of showing it upon their balance sheet, they move over to some other entity's balance sheet. It is no longer on the bank's books. This is called off-balance sheet bookkeeping. The head of the FASB said that you would be cornered. They are not showing the liability side of the ledger on the accounts payable because it has been moved over to someone else's balance sheet. It's called cooking the books in layman's terms. The IRS does the same thing when you tender them a negotiable instrument. They accept it and never return it, but don't adjust the account. They pretend like nothing happened. They move them off the books so that the collection agent looking at it, he is only looking at the accounts receivable ledger, not the set off. That's why a lot of y'all say this stuff doesn't work. Y'all send out these documents to the IRS. This is exactly what they're doing. They're never giving it back to you because they're doing this without your knowledge or your consent. And now you know. When a straw man is when a straw man is charged with speeding, he is giving a charging instrument, i.e. complaint, ticket, whatever, all the same. It is the same as a claim by the bank that shows that someone has failed to make a mortgage payment. It is a commercial entry from a corporation showing that there is a liability on your part and that is an account receivable and they are in the capacity of a creditor and making you appear in the capacity of a debtor. So the clerk, which is the court clerk, has an accounting charge against the straw man, but you operating the account. It is your responsibility to bring the recoupment in behalf of the real party of interest, which is you, because you are the ultimate creditor. If you raise the claim against the liability side of the account. Did I not say this for years? I know I said it. For y'all that are new here, I have a lot of videos going back to yesteryear. I said this. This is the reason why I said that a lot of people who fill out their UCC1 and say you're the debtor, you are doing it wrong. You were supposed to put in the secure party section your name, not a title adjacent to identification. Your legal name is separate from your personal name. But you don't have to take my word for it. The UCC1 describes it itself. Now, what is the subtractive principle involved in that? It allows them to avoid fraud. Question. The government does everything correctly. They never make a mistake. The government is invoked in securitization that appears to be a fraud. This is immunity for people who understand the procedure. Only the unlearned are fooled into voluntarily entering into fraudulent contracts. It does not work if you get frustrated and angry at the fraudulent results of your own ignorance. When you sign a promissory note to create the mortgage with the bank to buy your home, at closing they have already sold your note to the warehousing institution. The warehousing institution brought money into the bank when they brought the note. At closing, they take the money and closes out the account on one side. The bank forgot to tell you that they don't have a liability on the receivable side anymore. Why do they keep asking to take your money? They have become the servicer of the account. They are not paying principal and interest. The payments are profit to the holder of the note. This is not stealing if we know how to make a claim for recoupment. They are using the note to expand the money supply. Under Title 12, United States Code 18130, subsection 1, when you deposit a promissory note, it becomes a cash item. It becomes the equivalent of cash because you have a cash receipt. So, closing on that note, let me explain something to you people. This is how the game is played. This is the rudiments to how the system operates by your ignorance. It says my people shall perish for lack of knowledge. Now, perish doesn't mean immediately. But if you understand mortgage and you understand the definition of what a mortgage is, it's a death pledge. See what I'm saying? Do not take my word for it. Look it up in Black's Law Dictionary. 4th, 5th, 6th, 7th, 8th edition. Now they have 9th out. Do what you will. Do your due diligence to study. But you can't get mad if this process doesn't work according to your ignorance about you being ignorant about how securitization works. But no, lo and behold, many people get on these wavelengths, they listen to somebody or something or some type of entity, and they swear that they got it all down pat. 20 minutes, 30 minutes, maybe an hour or something. This takes years of education. I'm just going to be the one to tell you. And a lot of people are not equipped to even handle this because they don't even have the materials at hand to even rebut the claim if they were to say that you were wrong. See, I'm very hard on my students in the class because some people just feel like they need someone to hold their hand through it. Remember, you can be assisted by somebody, but it is your primary goal to be power of attorney in regards to how you deal with securitization. And pretty much you're going about your commercial affairs with knowledge. That's why I talk about the codes. Hey, love. I talk about the codes. I talk about the statutes. I talk about the forms. I talk about the procedure. Because if you have all this in place, they cannot argue with you. You see what I'm saying? They cannot, because you're referring to guidelines that they have to go by. Instead of you just saying, well, y'all owe me some money, they're going to be like, how? Let's just hypothetically say if they even wish to entertain that sort of question or statement, I should say. So within regards to it, it is your responsibility and your due diligence to understand what securitization is and how it is illegal and how it can affect you if you are not in a creditorship position. Remember, in commerce, the only people they recognize are creditors and debtors. They switch the position to make themselves creditor through misleading presentments, i.e. claim, i.e. mortgage statement, i.e. foreclosure. All of these things are done to keep you believing that you owe them. But now you just understood the mathematical and the magical principles behind how their contracts work. You must point out the fraud. It's not about the property. It's about the transaction that made the property available to you in the first place. It's getting to the root. The root is always the contract. But the contract never had full disclosure. Because again, if you received a mortgage loan, you never received a loan. You financed it yourself. You see what I'm saying? When you see the corresponding UCC codes like UCC 3419, it says accommodation party, which means your signature paid for it. But because they send you these misleading notices and they play around with third parties to keep their hands clean from the fraud that you now know about, your job is to basically inform them, you never gave me a loan. And remember, no contract is permanent because there's a such thing called rescission of signature. You can rescind your signature at any time because that is the truth. Once you invalidate that signature, it makes the whole transaction null and void. No contract can be enforceable without the consent of both or more parties. So again, once you rescind your signature, they can no longer refer back to that signature that's on the original contract that's saying that you owe them because you rescinded that. I know nothing about that. And then if you go to court, you state your claim. Basically, you're letting them know point for point they violated GAP, they violated gas, they violated United States Code, subsection 12. You see what I'm saying? All these things must be your ammo in order for you to understand the liability side and how they're trying to stick it with you. But in reality, you were the creditor. You were just tricked through false and misleading representations. Securities fraud is a punishable sentence. Some people can face up to a $100,000 fine or 20 years imprisonment, or both. Don't take my word for it. Look it up yourself. And that's in less than 26 minutes. The reason why you have to understand why so many Americans are in the situation that they're in is because they are so ready to sign contracts, not knowing that every contract is a binding obligation. Unless, of course, you go into it with full disclosure, which never happens. They write up these forms, and most forms, if not all, are written by attorneys with specific intent to defraud the signer. There's a such thing called a bilateral contract and a unilateral contract. A bilateral contract nowadays basically really doesn't exist, except in certain instances when it comes to wills and estates. That's a different story. But also to mention, a unilateral contract is a one signature contract. That's all they need is your signature on there, binding yourself to all the terms and obligations on the paperwork. This is how they track you, trip you, and steal from you. Okay? So it's just like whenever you sign up for auto, you're just happy. You're just elated. You just love it because you got a brand new vehicle. Not understanding that the state and the dealership or the automotive dealership, wherever you got it from, doesn't matter. They take personal documents that you signed and you gave them permission to send your vehicle into public registry. If it belongs in public registry, guess who it belongs to? It belongs to the public. I don't care how long you've been paying off on a note. I don't care. You miss one, you miss two, you miss three, they're coming to get it. Not based on your failure to perform, but based on the notion that it's public record, that it belongs to the public. Once you take it off of there, it's no longer showing as you being a party to a contract that you unwittingly enforced yourself due to a deceptive signature. Same thing with mortgages. Trust me, they do this all the time. Before you sign anything or anything for the future, make sure you get the name. I'm talking about proper name. Make sure you actually get all the information necessary from the initial signing of the contract. Just because someone's presenting something to you does not mean it doesn't have venom within the clear in between the lines concept of them wanting to enforce it. Keeping yourself out of commercial harm is the best way to live. That's all I can say. But the only way you're going to do that is if you are fully informed and you stop letting these thieves who portray to be lawful people who are nothing more than fraudulent banksters take your property. That is what is important about redemption. I've been saying this for years, and I'm going to keep saying it until it is what it is. But redemption is getting yourself out of the liability position and putting yourself in creditor position. The reason why public officials or anybody that operates in the public can't use UCC is because they have an official capacity. UCC is for creditors. Creditors do not operate in public. They operate on the private side. So if you have information, in closing, if you have information to the contrary, that you are the creditor, there is no one that can hold a substantiated claim against you. Your job as the creditor is to receive it for its value, accept it, and entitle yourself to the recoupments according to FASB. That's all you have to do. Simple as that. But the choice is yours alone. It is what it is, people. This is part 2, securitization. Why it is illegal and what you can do about it. Like I said, if it's your first time viewing this channel, like and subscribe. Hey, the more people know, the merrier. You know what I'm saying? But please like, please share, please hit the notification button so every time I upload a video, you are not held outside of the loop. And basically, you'll be properly informed. Simple as that. So, take it from me, a person who's been doing this for years. I owe nobody. I don't get any mail saying I owe anybody. I don't get any emails saying I owe anybody. I owe nobody nothing because once it hits my desk, I take care of it. For you people who I call the ostrich people, who get a notice and it says you owe something, your worst mistake is setting off your paperwork. The moment you put your hand on that envelope, open it and address it accordingly. Don't sit here and let time fly, because 30 days can fly by before you know it. And I'm letting you know right now, they're banking on you not being on time, because your ignorance is what keeps them getting paid. And nobody sees to bat an eye about it. But you got the remedy for part 2. Stay around for part 3. And like I always say, like and subscribe. I leave my email information and my Google number in the video description. Serious inquiries only. Outside of YouTube, I have a personal life that I have to attend to. I know the world is a busy place, and I'm a busy person inside of that place. So, peace, light, love. Consultations, hit me up. Agents, man, fuck you. I'm out.